I would like to introduce their tribe.
Thank you very much, Virginia Sloan. It's not a matter of giving up a career, it's a matter of having the opportunity to do something that I think is extraordinarily important and a great privilege. Chairman Conyers and Chairman Scott, and I'm also addressing Ranking Members Smith and Gomer. I want to thank you for convening this summit on the right to counsel, which is an issue of critical importance to Attorney General Holder, to President Obama, to this administration, and to the initiative that I am honored to lead as Senior Counselor for Access to Justice. I do appreciate the chance to be here both to discuss the role that the new initiative hopes to play in addressing the crisis in indigent defense, but also to learn from you and to hear the insights of my fellow panelists. Let me just begin quickly by giving you a brief overview of the Access to Justice Initiative and our mandate. Addressing the crisis in indigent defense is a central focus of the initiative, but in addition to that, it includes several distinct but related missions, and I want to say a word or two about how they are related. We're charged to enhance civil legal representation for those without great wealth, including the middle class as well as the poor. Let me pause to note something that Congressman Conyers mentioned when he said that people have been forced by the crisis in indigent defense into circumstances in their lives in which they're confronting mortgage foreclosure and other personal disasters in which it turns out that they are also insufficiently represented on the civil side. So it's impossible really to separate the strands of indigent and civil defense. There is a crisis in both. Another mission of the initiative that I've been asked to lead is to promote less lawyer-intensive and court-intensive solutions when possible. Obviously, when you're talking about people being criminally prosecuted, courts and lawyers are indispensable. There are many aspects of life in which people face crises in which it really is mostly the legal profession that believes that they need lawyers. It may be that what they need is legally trained professionals who are not necessarily lawyers and looking for opportunities for alternative dispute resolution, alternatives in which we are not necessarily going to court, but in which we're seeking just outcomes. That's another mission of my initiative. Focusing with special care on the rights of the most vulnerable among us is one of the things that the President and the Attorney General has charged the Access to Justice Initiative to do. The mentally ill, unrepresented children, the homeless, disabled veterans, victims of sexual violence, victims of domestic violence. There are needs on both the civil and criminal side in all of these areas. The next of our missions is to work with and represent the interests of federal, state, and tribal judiciaries in strengthening their ability to provide fair, impartial, and independent adjudication. Courts that are starved of funds, judges who face re-elections in which there are enormous contributions, are all challenged in providing meaningful access to justice. We're also charged to reach out to foreign ministries of justice and judicial systems in our efforts to improve access. I was asked by the State Department to head a U.S. delegation to Poland recently. We learned a good deal from them, from their legal clinics, about what they are in turn learning from the legal clinics in South Africa. There are lessons to be learned in other countries, and we're trying to learn them. And finally, encouraging the development of more thoroughly evidence-based solutions to problems in the delivery of legal services. We are looking at ways of encouraging the funding of studies that will enable us to document just how much can be saved by having better indigent defense at the front end and not simply loading all of the investment at the back end. Since the launch of this initiative on the 1st of March, we've actually only been in place for several months, but it feels like quite a long time because we've had a lot to do. We've met with a broad range of national indigent defense advocacy groups, public defenders from across the country, including my fellow panelist, Carlos Martinez. We've had a chance to listen to their concerns, learn their suggestions of ways we can help fix a number of problems. We are very much focused on serving as a sounding board and an antenna for the Department of Justice to learn about issues that are arising around the country. There are people come by my office and it says, access to justice, and they want their picture taken. Not necessarily with me, actually, but with the access to justice sign, because it means something to people that there is an office in the Department of Justice that provides that sounding board, that is a place where people who are working hard on these issues, as those of my fellow panelists and as the chairman of the committee and the subcommittee are doing, a place in the Justice Department where they can get a hearing. We're reaching out to both state chief justices and federal circuit courts and major law firm pro bono departments to encourage the creation of arrangements that recognize and reward high levels of pro bono performance in legal services in general and in indigent defense in particular. It turns out that some arrangements that some circuits have brought forth a great deal of the effort that is latent in the legal community. Lawyers who actually want to do something with their lives that feels meaningful before it's done. We're working with state court chief justices in particular to encourage them to implement rule changes where they have the power without legislation, but simply by rule, to improve the situation. Let me give you just one example. Waiver of counsel in juvenile proceedings. There are lots of proceedings in this country in which juveniles haven't even talked to a lawyer prior to the time that they allegedly waive the right to counsel and enter into a plea agreement. Courts can, and we believe should, end that practice by rule, and I'm going to be addressing the National Conference of State Chief Justices on issues of that kind. We've met with especially innovative judges like the Chief Judge of New York, Jonathan Lippman, the author of the landmark Pearl Herring decision, which recognizes the possibility of making a systemic challenge against a state legal system that fails to meet its fundamental Sixth Amendment obligation to provide indigent defense. To see how, in a case like that, we can look at the kind of volcanic energy of this chief judge and perhaps bottle it and transplant it to other parts of the country. We are learning that there are pockets of energy and innovation in many parts of the country that, if replicated, could make a huge difference through systemic statewide reforms. We're working closely with the Office of Justice Programs and its quite remarkable Assistant Attorney General in charge of that office, Lori Robinson, to create and expand grant programs geared toward addressing the crisis in indigent defense. One thing we've heard loud and clear is that there is a huge need in this country for research and effective data to help defenders make policy decisions and help them make the case on the Hill and elsewhere for higher levels of funding in a time of scarce resources, in a time when there is enormous competition for resources. It's not always easy to convince people that more needs to be spent on indigent defense, but you can convince them partly with convincing data about how much it saves in the long run. And I'm glad to share with you an announcement that I was able to make on behalf of the Justice Department yesterday, speaking to about 1,600 people at the National Institute of Justice's annual conference, namely that my initiative will be teaming up with the National Institute of Justice to issue a new research grant solicitation to examine access to justice issues. Finally, and I don't want to take much more time, so let me close, on the question of Edward Byrne Memorial JAG formula funding. It's a source of funding for criminal justice systems in the United States. One thing that we want to be sure emerges from this critical summit is to clear up what appears to some to be some ambiguity as to whether the Byrne JAG funds can be used for indigent defense. The answer is an unequivocal yes. Attorney General Eric Holder asked me on his behalf to be clear that not only can Byrne JAG funds be used for indigent defense, but the Department of Justice is strongly supportive of that use of Byrne JAG funds and strongly supportive of the states that choose to utilize those funds for that crucial purpose. I want to thank you again for inviting me here today, and I look forward to your questions and to the conversation that will follow.
Thank you very much, Professor Tribe. It's now my pleasure to introduce Blanca Clark, who will co-moderate the panel with Ms. Sloan. Ms. Clark is counsel in the Justice